We have provided a strong legal and constitutional framework that respects the Canadian Charter of Rights and Freedoms and the values that the Canadians hold dear. With that kind of underpinning under this legislation, the agencies can do the work that they need to do with the full confidence that they have the legal and constitutional authority to do it. And Canadians can be assured that this is a transparent process, an accountable process, and that critical agencies like the new National Security and Intelligence Review Agency, the so-called Super-CIRC, that agency, the Intelligence Commissioner, as well as the agencies themselves, and in many cases the supervisory capacity of the federal court, that all of those safeguards are in place to protect rights and freedoms.
Well, we think it's a dangerous step back from certain provisions that allowed law enforcement to intercede when there was a threat to public safety in Canada from a commission of a terrorism attack. We use specifically the example of the tragic case of Warrant Officer Vincent in Quebec, where police were aware of a radicalized young man but did not feel they had the threshold requirement to detain him. The changes made in the last Parliament would allow law enforcement to detain in a court-supervised manner risks such as those. The two specific changes they've made today with respect to having to counsel in the commission of an offense and detention being necessary as opposed to likely to prevent an attack will actually make it hard for law enforcement to do their job. It's a big step back by the government to keep an election promise that was ill-advised by Prime Minister Trudeau. He voted for Bill C-51. He praised the specific and limited use of preventative arrest in the case of risks of terror attack, yet now he's undoing those same preventative arrest measures.